Reddy Neumann, Brown, PC. From April 1st onwards, it's Reddy Neumann, Brown, PC. We started our journey in 1997, April 1st, and now we are here 27 years later. We added another the person, Stephen Brown, will be the person, will be named partner in his office. I mean, what do we have today? Every Tuesday we bring in immigration updates. What do we have today?
Today, everything H-1B lottery. So we've been talking quite a bit about it, but it happened already. So yesterday, USCIS announced that they completed the lottery process. They've completed uploading all of the selection notices in my USCIS account. So people who have been selected should know by now, or their employers or attorneys should be in the process of updating them. And we're not expecting, we won't be getting any more selection notices in this round. So we'll talk about what happens next if you were selected, what options do you have if you have not been selected, whether we think there's going to be a second lottery in the future. We're also going to be talking about premium processing for the various I-140 petitions. Is it worth it to pay that extra money in order to get a faster result of the I-140 petition? We get a lot of questions about H-1B amendments, particularly when the employee is working remotely from home. When is it necessary to file an amendment? What happens if the person who's working from home is actually moving their home from one location to another? When is an amendment required? In what situation? And what is the timing for that amendment? Lastly, we'll talk about a common issue is job loss when your I-485 is pending. Is there a 60-day grace period? We know there is one for H-1Bs and other work visas, but what about when you have the C9 or the GC EAD? Is there any grace period for that?
Emily, on the selection of the lottery, those people who got selected in the lottery, though, they need to watch for the cap gap. That means that if your STEM extension or OPT is expiring between April 1st and October 1st, though, the deadline for you to file may not be June 30th. For example, if your STEM extension is expiring in April 30th, you need to file the H-1B by April 30th, not by June 30th. As everybody knows that we have until June 30th to file the application, but not for the people whose OPT or STEM extension is expiring within the period of before June 30th. Also to note is that when you file for the H-1B, if you have any dependents on F2 visa, or if you're, let's say, for example, you're an L1 and you're moving from L1 to H-1B, make sure that you file the H-4 also, because people forget it and they realize it in October. Yes, you do have time until October to file for the change of status. You don't have to file it right now, but it will be very prudent to file the change of status for the dependents right now instead of filing it at a later date. Those people who are in United States, and if you are on F1 visa, H4 visa, or L1 visa, or some other visas, the best way for you to do it is file a change of status application to the H-1B. Do not file the consular processing though, because technically speaking about, even if the H-1B is approved, you're not counted toward the H-1B until you go and get the H-1B stamp though. However, if the change of status is approved on October 1st, you're automatically moving into H-1B. There are some people that will tell me that, oh, I have a lot of STEM extension, I don't want to pay that much taxes. My employer doesn't want to pay that much taxes. It is not worth, guys. The reason is that if you lose the job, which under the circumstances, we see a lot of people losing the job under the economy that we are going through, then you will not be fit. Then you will have to go through the lottery system again, because you're not technically counted if you have the H-1B approval without the I-94 effective date on October 1st. So don't choose the consular processing, choose the change of status. Now, there are some people who are L1 visas and H4 visas. What they want to do is that they want to be counted toward the H-1B, but at the same time, for example, for the H-4 EAD, they want to have the flexibility of the H-4 EAD. That can be achieved. You can still file the H-1B with change of status effective date October 1st. And on October 2nd or so, you can just go to Mexico and come back on H4. There are ways, creative ways, where you could be technically be counted toward the H-1B and still retain the H-4 at a later date without interrupting anything. So please consider change of status. Don't fall into the trap of consular processing. Of course, for the people who are outside the country, we know that they don't have an option of doing the change of status. They will have to go to consular processing. Anything else, Emily? Tips for those people who are applying for the
Yeah, this is particularly for F1s. If you do apply for the change of status, which we generally recommend, and you get that change of status approved, and you later lose that job, and it's before October 1st, a lot of people have the opportunity to withdraw your H-1B to continue on OPT instead. Now, if you do that, you're not going to be counted in the cap, so you're going to have to go through the lottery again. So a lot of times we don't recommend that. But be aware that the timing of the withdrawal is super important and very long. And what happens every year in October is people who had their employer withdraw the H-1B so that they could continue on their OPT or STEM OPT, USCIS does not process the withdrawal by October 1st. What happens? Their SEVIS record gets automatically terminated by the ICE system because that system shows an H-1B approval has been issued. Now, you can request a data fix, while your school can request a data fix of your SEVIS record to reopen it and make it active again so you can continue on your OPT or STEM OPT. The problem is they won't do that until you actually receive the confirmation of withdrawal back from USCIS that gets sent to your employer. And every year for the past, I don't know how many years, they've been taking longer and longer and longer. So I have people that the company submitted the withdrawal in August, September 30th, still hadn't received it. SEVIS record gets terminated. They're trying to continue on OPT, but their H-1B is still active, so they can't get their SEVIS record reopened. USCIS didn't issue the withdrawal confirmation until January. So October, November, December, that person was completely in limbo, wondering how am I on H-1B? Am I on OPT? Am I violating my status because I'm actually working for a different employer now? Or am I safe to do this? And there's just no answers out there, and there's nothing you can do to speed up USCIS processing that withdrawal. So if you come into that situation, before you decide that's what you want to do, make sure you're aware of that situation and understand how it's going to impact you. The other option is to let the H-1B take effect from October 1st. Now you have a 60-day grace period to file a transfer to any other employer. You don't have to lose your cap number. You lose out on the rest of your STEM or your OPT, but sometimes that's worth it when only 25% of people are getting selected in the lottery each year.
And Emily, for those people who do not get selected in the lottery, let's discuss some of the options that are there for them. One, if you have a H4 option, definitely you can go to H4. That H4 EAD option is much better, of course. You can definitely choose that option too. There are also cap exempt organizations. If it's an organization which is non-profit and it's a higher education institution, for example, a university and some educational institutions will fall into that criteria, you can still file the H-1B without subject to lottery. You can look into the B2 option that's only allows you to stay temporarily, but probably not a very good option, I would say. Emily, what about the O1 option? Can you explain what that is? I mean, can they file a O1 people who are on F1 visa or H4 visa?
Yeah, it can be an option. It's definitely a much more available option now under the current administration than it was before, particularly if you happen to be in the STEM field, working in AI. In response to that executive order, the Biden administration has really opened up O1 as well as EB1A and NIW. So you could potentially, there's 10 different criteria. You have to prove that you meet at least 3 of those criteria at a bare minimum to show that you are top of your field, extraordinary ability. So it's very similar to an EB1A petition, but it's something to consider, particularly if you graduated with your PhD and you've had your 3 years of OPT time. Maybe you've started a business and you've been working in that since you graduated. Something to look into as a fallback option. And I also want to mention on that cap exempt employer, If you do get a job with a cap exempt employer, once you have that H-1B in place, it opens up the opportunity for you to work for a for-profit employer concurrently without going through the lottery. So you can work your cap exempt employer job, and then you can have your employer that filed for you in the lottery sponsor you for an H-1B that's concurrent to your cap exempt employer. And you can work part-time, even up to full-time, for both companies at the same time without having to go through the lottery. So that gives you more flexibility if you get a nonprofit or a cap exempt employer.
What about this day one CPT though? I mean, it's an easy option for a lot of people. Hey, you go to the university, you don't have to go to the school, and they give the day one CPT work permit though. I do see a lot of YouTubers advising people to go on a day one CPT. What's your opinion on it?
Definitely not a fan of them. There are things that sound too good to be true, and they often end up being too good to be true. So when a school has practically no requirements for you to apply, anyone can get in. You don't have to take the GRE, you don't have to take the GMAT or anything like that. You can get into the school any time of year, in the middle of the semester, halfway over semester, whether it's summer, winter, fall, any day, you can just start. And then they allow you to work full time while school is in session and during your first year of your grad school, which is generally a violation of the F1 requirement. So these are all the so-called benefits of these day one CPT schools. And yes, they sound too good to be true because they are, because normal schools are not authorizing this. It has to tell you something. If you go to University of Michigan, University of Texas, Texas A&M, University of Houston, any U.S. a household name in your state, they do not give CPT on day one. They don't allow you to work full-time while school is in session. And it's because they think that's a violation of the F1 regulations. So these schools that are authorizing it, there's only about 5 in the whole country out of how many F1 granting schools, 3,000 schools. That has to tell you something, that these are not in compliance with the law. We've seen before schools that were not in compliance with the law get shut down. We had Tri-Valley University completely shut down and raided. We had Northern Virginia University that was shut down but not raided. We had 2 fake universities that ICE set up as a sting operation to get unsuspecting students who wanted to be able to work instead of study. So I think that these schools are violating the regulations, and you're at risk for your future immigration if you attend one of these schools. So I definitely don't recommend it.
Emily, University of Northern New Jersey is a fake university by the ICE, Immigration and Customs Enforcement. And Silicon Valley is what you named. There's another thing called Tri-Valley. These are the 2 universities that were raided, and their good number of their staff are right now in jail right now because they issued a day one CPTs. And these fake universities are the one, Farmington University and University of Northern New Jersey. So we are very cautious in these things. We said multiple H-1B applications were fraud, and a lot of people said no. Later on, it turned out that a lot of those H-1Bs are getting revoked now. So we don't want any of your future to be destroyed, though. Definitely, you have an option of going outside the country and coming back. And even if you're outside the country, you come under the master's quota. You do not come under the bachelor's quota. If you have completed the master's degree, you still come under the master's quota, whether you're outside the country or whether you're inside the country. Emily, going to the next topic though, premium processing for I-140. Is there a chance that just because you filed in premium processing that you have a higher chance of getting an RFE?
Well, I would normally say no, but I just got one today that is a completely ridiculous RFE, so I might be changing my mind on that, on an EB1C. It's as if they didn't look at anything I submitted, so I might have a differing opinion than before. But generally, no, I don't think that it triggers RFEs. And even if they do, you have a faster response time once you respond to the RFE that I do think is worth it, especially if this is your first I-140. It's very important to lock in your priority date before anything happens with your job. So the longer it takes that I-140 to be approved and the current, labor market conditions, the likelihood of you potentially losing that job while you're waiting and then you lose your priority date, that's a big problem and a big fear. So locking in your priority date by getting the I-140 approved as quickly as possible is a huge benefit of premium.
One other thing is advantage for premium processing is that if your I-140 is approved and it's not been withdrawn for more than 180 days, you get to keep that I-140 forever. You get to keep that for extending the H-1Bs. You get to keep that for the H-4 EAD. Even if you move from company A to company B to company C to company D, you can still use the I-140 if it's been more than 6 months after it's been approved. So for example, if you don't do premium processing, then it takes about 6-7 months for you to get the I-140 approval. And then let's say you lose the job and they withdraw the I-140, you're in big danger. For that reason, also, we recommend filing a premium processing of the I-140. I mean, one thing we forgot about the H-1B cap selection, even though a lot of our audiences are Indians, there are some people who are non-Indians. Emily, what are their options? Can they directly file the green card and get the green card instead of going through the H-1B?
Yeah, definitely an option, especially in the EB1 category. If you qualify for EB1A or EB1B as an outstanding researcher, you can go straight to the green card because that category is current if you're not from India or China. EB2 is practically current. You likely would be able to get through the Perm and get your I-140 approved while you're waiting for the date to become current within the 3 years of your OPT and STEM OPT time. EB3, maybe not so much anymore. It's backlogged for the rest of world even. So that might not be an option. And it might be harder and harder going forward for people to do that while they're continuing on their F1. But as they keep going on F1, obviously in future years, you can continue to be put into the lottery while you have your green card process going on as well.
Yeah, but for EB2, definitely January 2023 is the priority date for the EB2 guys. So yeah, there's a chance that you should try filing a green card and just completely not go through the lottery system, especially if you're not from India. Emily, on the people who work remotely though, I have an H-1B with Florida as my job location. My company is in Florida and I'm now moving to Dallas. I'll be remotely logging into my Florida company. Do I still need an amendment?
Yes, absolutely. It is based on where you're actually sitting when you're doing the work, not where your company is located. And you need to have that amendment filed before you actually start working in the new work location. I still see a lot of companies wait 6 months and then file the amendment and then end up with a denial because they filed it late. And USCIS can tell you filed it late. They can tell where you're actually living at the time that petition has been filed. So don't mess around with that. Make sure that the amendment is filed before you start working in the new work location.
And a lot of people think that the USCIS doesn't know, but they will come to know. Emily, the 60-day grace period, everybody knows that if you lose the job on H-1B, you have a 60-day grace period. Let's say I am on H-1B and I filed my adjustment of status and adjustment of status is pending. I know on my H-1B I have a 60-day grace period. Is it true that if on the EAD, that since my EAD is valid for the next 2 years, if I let my H-1B go, even if I don't have any job or job offer, I can continue to stay and get the green card eventually on the adjustment of status?
Not exactly. There definitely is no grace period on the EAD or pending 485. So it is expected that while your 485 is pending and at the time you filed it, you have a valid offer of employment that's supported by either a labor certification or an I-140 petition. At the same time, the whole process is based on an offer of employment, not necessarily actual employment. So there may be situations where there can be a gap between one company to the next, using AC-21 to move your green card process to the new employer, as long as the new job is in a similar occupational category and your 485 has been pending for at least 180 days. The problem comes in is often, especially for long pending 485s, you'll get an RFE asking for a supplement J to confirm that you still have a job offer before they're ready to approve the 485. If you happen to not have a job at that time, that can cause your 485 to be denied. So that's a very dangerous situation. Same situation if you happen to be called in for an interview and at that time you don't have a job offer. So having those gaps of employment can be very risky. Based on a pending 485, there's no grace period on the 485. There may be options to have that job offer, such as self-employment. That is allowed under AC-21 if you're going to work in the same kind of field for yourself. You could have your spouse who has an EAD open a company and sponsor you under AC-21. There are different options there. They definitely come with their risks. So you should certainly speak with a qualified immigration attorney before you take that route to understand what those risks are and how to minimize them. But there are still ways to proceed and still receive the approval of the green card.
Shall we go to question and answer, Emily?
Yep.
There are two questions that came out from Bautik Patel. Can the H4 EAD be filed along with the I-140 application, or do we have to wait for the I-140 approval? You have to wait for the I-140 approval for you to file the EAD, H4 EAD. Questions from Ashish Gupta. I have an I-140 approval. My child is 16 years old. Can I file for H4 EAD for my child? Unfortunately, the EAD, H4 EAD is only for the spouse. It's not available for children, so they cannot file H4 EAD.
Nitya from YouTube says, happy 27th anniversary. Thank you very much, Nitya. We appreciate that. Sujit says, any update on domestic visa renewals? Are they going to allot more domestic visa slots? We have no updates. We've not heard any feedback from the Department of State. I would be pretty shocked if they didn't continue the program. It's intended to be a pilot program so that they can work out all the kinks on a small number of applicants and then open it up further from there. So they may open up more slots first. They may open it up to dependents, and then they may open it up to other visa categories over time. No idea on the timeline of that. They haven't, produced any kind of report about how it's going so far. We've got very limited feedback from people who've gone through the process. So that's the update there. Not much of an update.
Question on 1099 for the hedge fund. I don't know what this NEC is, but if you are not involved in managing the hedge fund, and you are getting the profit from the hedge fund, we don't see any problem. If you are on a non-immigrant visa, we don't see any problem. If you are involved in the hedge fund and working or managing the hedge fund, definitely you need to have a work permit for it. But if you're just investing and you're making money from the hedge fund and you're getting the payment from the hedge fund, absolutely not a problem.
Question on with the current fee structure, what would be the estimate to file an H-1B 7th year extension and an H-4 EAD in premium? That's going to be a lot of math. So assuming the 7th year extension is at least the second extension with the same employer, then the company has to pay the base filing fee, which is now $780 plus $600 for the asylum fee, assuming they have more than 25 employees. So that's the H-1B filing fee plus $2,805 for premium processing. Then I'm assuming you also need the H-4 extension, which is now $470. And then the H-4 EAD application is now paper filing $520. So I don't know what all that adds up to, but it's definitely a lot more than it should be.
Yeah, previously when we used to get called, hey, what's the filing fees? It was an easy answer. Right now, there are like, we have to do a lot of calculations, a lot of pluses and minuses to just come up with what is the filing fees? Is it an extension? Is it a second extension? Is it more than 50 employees? Is it more than 50 employees? Is it less than 25 employees? Oh my goodness. It's amazing. It's amazing. And good luck with it, Henry. Can I change from H1 to H4 EAD and back to H1B? This question is coming from Deepa. Deepa, the answer is yes, absolutely you can. If you have the leftover period of the H1B, you can come back on H1B. And if you already have an I-140 approval, you definitely can come back at any point of time. Absolutely not a problem. A lot of people who are moving into H4 EAD, then getting their I-140 approved, and then moving back to H1B, that's possible too. At the time when you are in H4 EAD, can a company file the green card application, get an I-140 approval? The answer is yes, you can.
P. Varma says, currently have an approved I-140, but my H-1B has always been with a cap exempt employer. In the future, if I can get an H-1B in the lottery and use my current I-140, will I be eligible, or am I not eligible because I already used up 6 years? So the I-140 makes you exempt from the 6-year limit, whether your employer is cap subject or cap exempt. So yes, you can switch to a cap subject employer in the future by going through the lottery and utilize your approved I-140 to get extensions beyond the 6-year limit.
Abdul Aziz has this question, Emily, and I want your attention on this. My lawyer says the H1 registration is still pending. Can I expect a positive response in the coming days? The answer is no, according to me. Correct me, Emily. Why? I'm right and I'm wrong.
I agree with that. Someone else had asked me that in-process notification was the notification in a few cases before the submission actually happened. So if it is still showing that, I don't think it was ever actually submitted. Therefore, it couldn't even be included in the lottery. I've not seen that in any of my cases. I believe that particular case status was showing up for people before the submission actually happened. But once it's submitted, it will say submitted, and then it can be included in the lottery. So it's possible it wasn't even included in the lottery, unfortunately.
Emily, there are 2 questions about the travel. 4K, wife H1B got picked up. She has a plans to travel in July and August of 2024. Yeah, that's going to create a problem for you. The reason is that if she applies for the change of status and she travels outside the country, the change of status is considered to be abandoned. That means that she won't be granted the change of status. And then you have to file the change of status again once she comes back into the United States. And man, the filing fees has gone up significantly. Will the company will be doing that? That's one thing. Now, the second thing is that can she come back and file it? No, you have to file this by June 30th. If you're going to file it after June 30th, then you can't file, even though you got selected in the lottery. So definitely either you alter the travel plan, or you can do one thing, you can get the H-1B approval, travel and come back, and then file the change of status again.
Yeah, or exit again and go for stamping.
Yeah, that's an option too. That's good. Exit again. So come back in July and August, go back again to outside the country, get the stamping and come back.
MIPTP says, does filing the I-140 and 485 not concurrently lead to better processing times compared to concurrent filing? We were experiencing that back when I-140 and I-485 applications filed together were being routed to the Texas Service Center because Texas was taking forever on the I-140 petitions. All those downgrades from October 2020 took forever to process. Nowadays, I don't think we're seeing the same issue because the 485 gets routed to the National Benefits Center, even if it's concurrent filing. I think it might take a little bit of time to get routed there, but we're not seeing those same types of major delays like we were after the October 2020 mess.
Emily, I want your attention on discussing two different issues here. And one is Juhi Shah has this question that she is lucky to get selected in the lottery, and then she's planning to travel to Mexico between 6th and 8th of June of 2024. She's on STEM extension, and she intends to file the H1B from June 10th to June 30th, somewhere in between that time. I have never seen any problem when people under these circumstances have traveled and come back, even though technically the intention for her would be a little bit different, where her intention is not to continue education, but want to work in United States on a permanent basis. I haven't seen any problem at the port of entry. Have you?
No, I have not either.
So technically she can go in June 6th and 8th and come back and then file between June 10th and June 30th. That's fine. Second question that I got is Divya is asking this question: will there be second lottery this year?
Always a good question. I would lean towards no this year for two reasons. Number one, this is the 5th time we've had the electronic lottery now. Hopefully USCIS has gotten better at predicting how many selections they need to make in order to actually fill the 85,000 slots now that we're on the 5th time around. At the same time, we do have the beneficiary-centric process. So the problem before with all these extra selections, they didn't actually result in petitions being filed because everyone thought, oh, we're going to get in trouble because we did this, which was the right thinking at the time, which is what we said all along. And so that was the reason why they didn't get as many petitions filed as they thought they would, and they had to go back and do a second one last year. So we don't have either of those problems this year. So I think the main reason for a second lottery this time around would be if something crazy happened in the economy, like another COVID between now and June 30th, and people just aren't filing because there's no jobs. Hopefully, knock on wood, that does not happen.
A question that came from the start: the person is working on L2 spouse visa. They have an employment authorization, automatic employment authorization. Can they convert into L1B while working in United States? To qualify for L1B, you must have worked for the company outside the country for at least 1 year before you came into the United States. So if you have worked for that company outside the United States and you are here L2S, you may be qualified to file for the L1B. But if you are working with the company here in the United States for 1 year, that will not be counted towards the 1 year period that you should be working outside the country. So if you would have been working outside the country for 1 year, you are eligible. But if you did not work for that company outside for more than 1 year, then you are not eligible to file for the L1B visa.
Chaitanya says, do Canadian passport holders who are born in India and residing in Canada need to attend an interview at the consulate for H-1B stamping? No. Canadian citizens are visa exempt, so you don't need to apply for a visa. You just take your H-1B approval notice and show it at the port of entry with your Canadian passport.
What are the months that you're receiving the labor certification approvals? This question is coming. We are looking into February. I'm just opening one which we received it today, February of 2023. And I've also seen some which were filed on March 16th. I've just opened the emails right now. We're seeing February and March of 2023 is what we are seeing the Perm approvals. This question is Vitali from Twitter.
Kieran says, is the new I-129 fee applicable only to paper filing, or is it online filing as well? Is online filing the same old price? And can we choose the online filing option? So although there are some forms that have different fees for online versus paper filing, the I-129 is not one of them. So all I-129s for H-1B, if it is a large employer, they have to pay the fee of $780. If it's a small employer, it's $460 plus the $600 or the $300 asylum fee. But every type of I-129 starting now has a different fee. So there's one fee for H1s, there's a different fee for H2s, different fee for unnamed beneficiaries of H2 versus named, different fee for Ls, different fee for O, different fee for TNs and Es. Every single one of them is different. It is like, I know attorneys aren't supposedly good at math, but yeah, it's going to take a long time to memorize all these fees.
It's going to be hard to memorize every time we have to go case by case, Emily. That's what I decided. Question, my spouse is, the prior date is current, my spouse is outside the country. What are the better options? I would recommend your spouse to come ASAP if they have a visa. You're telling that they are an H4 visa. Please have them come ASAP and file the adjustment of status. Then they can go outside the country. That's a better option. There are some dangers if you alone file the adjustment of status, though. And what happens is that sometimes I have seen some cases where they can issue the green card within 3 months, 2 months, sometimes they get the green card, though. The problem is if you get the green card, your spouse is stuck outside the country, they can't come here on the H4 because you're no longer on H1B. And it creates a lot of problems if you want to file by yourself. I would rather withhold filing the application rather than filing just for yourself. Wait for your spouse to come in. The best option definitely is bring your spouse ASAP into the country.
Clevy says, if the H4 change of status and EAD is approved before the H1B transfer, if both of them are pending at the same time, this is very common. You lose your job on H1B, you've got your 60 days to file the change of status or the transfer, and in between you file the change of status to H4 and H4 EAD is kind of a backup plan. And then you end up finding the job, filing the H1B transfer as well. Both are pending at the same time. What happens if the H4 and H4 EAD get approved and then the H1B gets approved and you actually want to be on H4? Well, that's where the margarita switch comes in handy. Automatic visa revalidation allows you to travel to Canada or Mexico. We like Mexico because you don't always need to get a visa to go to Mexico. Have a margarita while you're there, come back and show your H4 approval notice that has the I-94 on it, show your expired visa stamp, whether it's an H stamp or an H4 stamp or any other stamp. It can be expired, no problem, and come back into the country as long as you're in Mexico for less than 30 days and you do not apply for a visa stamp.
Rahul has a bachelor's degree, but he got picked in the master's quota. Is that going to be a problem? Yes, it's going to be a problem because you got selected in the master's quota, not in the bachelor's quota. That is definitely a problem. I don't think so. You should definitely contact an immigration lawyer, but I don't know how the mistake happened by, I don't know, you, your employer or your lawyer, but definitely it's a problem.
Sied says, currently in the 6th year of H1B, can I apply for a 7th year extension if the perm has been denied, but an appeal has been filed? If the perm was filed more than 365 days before you hit your 6-year limit, yes. You can use the time that the perm was pending plus the proof that the appeal is currently pending to get a 1-year extension while you hopefully work on a new perm application, because that appeal is going to take forever. So you might have to do every 1 year extensions or get the new perm filed, get the I-140 approved, and then get 3-year extensions after that.
Avi Narayan has this question. After filing N400, which is citizenship application, can I travel outside the country? Will it going to create any problem if I travel outside the country? No, it doesn't. If it's a brief travel, let's say, for example, a month or 2 or lesser than that period of time, absolutely not going to cause any problem, though. And I know that a lot of forum will say, yeah, there is something. Now, when you go for the interview, though, the officer is going to ask you the question, have you ever traveled outside the country after filing the N400? You just have to answer yes to that question. And they will ask you to sign the travel dates on the N400, but it doesn't cause any problem in you getting the citizenship approved.
2 questions that are similar that deal with delaying the H-1B start date. So Krishna says, If I get my H-1B consular processing approved for 3 years, can I convert to H-4 from H-4 to H-1B in my 3rd year? And another question, where did it go? Srinivas, if my H-1B petition is approved, can I delay coming into the US by a year or 2? How long can I delay? So yeah, technically in a perfect world, you can delay the entire time that that petition is approved. So if it's valid until 2027, you just have to activate it before the end date in 2027. But you're all assuming that that job is still there in 2027. That's a big unlikelihood in today's labor market. So you may hold off thinking that you're buying more time and can use your 6 years in the future. And in reality, you may lose out the H-1B altogether and have to go through the lottery again because you were never able to activate it because you lost that job by the time you tried to get into the US or convert from H-4.
Krishna Reddy Velagala has this question. My wife is an OPT. Can she get a H-1B? And after getting the H-1B approval, what he meant was change of status, can she convert back to H-4? And if she does that, can she able to use the H-1B in the next 4 or 5 years if needed? Absolutely. It's not 4 or 5 years. It's up to 90 years, 90 years. Why not 91 years? I don't expect your wife to live that long.
Harindra says, is it possible to activate the H-1B before October 1st? No. The start date is October 1st, no matter what, for every fiscal year. Now, if you're outside the U.S., you can apply for your visa stamp before October 1st, but the earliest you can enter the U.S. is September 20th, 10 days before the start date.
Monica has this question. A lot of master students applied for the H-1B, got selected. Will there be any problem? We don't think so. A lot of people got selected. It definitely is much better percentage than last year. Maybe your friends are lucky enough to get in the lottery. We don't see any problem at all. I mean, if they have a master's degree here in the United States and they got selected, that's perfectly all right. It's good luck to them. That's good news for them.
Calpec says, I'm a visual effects artist based in California. After 3 attempts for the H-1B lottery, I'm considering applying for the O1. Does Reddy Neumann offer assistance with this category? Yes, we do. Rebecca Chen in our office handle those. So you can definitely reach out to her to assess whether you might qualify and get that filed.
Second. How much time it's taking for the prevailing wage approval these days? It's taking about 6 to 8 months right now to get the prevailing wage.
Nazook says, what do you think coming elections will affect the EB1 and H-1B extensions? Well, if Trump is elected, we've seen lots of what he's already tried to do and actually accomplished while he was president, and he wants to go a whole lot further. So I don't think it would be anything good.
Mayank has this question. If people have applied for multiple companies, yes, all the companies will be notified. Emily, do we know that if they notified that they got selected to 2 different companies? I don't think so, is that right?
No, just each company gets their own collection.
If a person has filed from Microsoft and Google, Microsoft got notified, Google got notified, but Google was not notified that this gentleman, John Doe, also filed with Microsoft, because Google and Microsoft still don't know that John Doe has filed with 2 different companies.
Ram says, I canceled my H-1B 221G interview. So next time, can I go to the Dropbox interview again? If I'm assuming the 221G administrative processing was not actually resolved. So next time you go for stamping, whether you tried Dropbox or not, you're probably going to get a 221G. So just plan on that delay, whether you do Dropbox or do the interview.
My wife is running a business on H4 EAD. She's planning to travel to India. Can she stay in India? And can she run the business from India? Absolutely, she can. If she's able to run the business from India, absolutely, she can run from India. I don't see any problem with that.
Anil says, do I have to withdraw the AP if I'm applying for a new one because I traveled after it was filed and it's most likely going to get rejected? No, you don't have to. I've done lots of refilings without withdrawing.
And how much percentage of the H1Bs got selected, though? I see a tweet from you.
I'm looking at around 25%, and that's what I'm hearing from other attorneys as well.
And does it? Can you segregate it between masters and non-masters, or is it combined in our office?
That's combined. Yeah, I haven't really looked into which ones were masters.
Masters.
Yeah.
Okay. So practically speaking, if it's 25%, though, the chances for what Monica was telling was that a lot of masters people got selected this time. Looks to be reality, because if it's 25% in general, though, masters people might have got a lot more percentage, especially compared to last year. It's much better for the masters people this time.
Nishant says, I lost my H-1B recently, have the approved I-140. Can I apply for the compelling visa in this situation to get a 1-year stay? I have a mortgage on my home. I'm assuming you mean the compelling circumstances EAD. So yeah, if you are still within your 60-day grace period, you're considered to be maintaining H-1B status, and you can file for the compelling circumstances EAD. The job loss by itself is not considered a compelling circumstance, but all of those financial problems that arise due to a job loss, like potential inability to pay a mortgage and those sorts of things, can be considered compelling circumstances. We filed a number of those. So you can reach out to Ryan Wilk in our office if you are interested in that.
Are the new H-1B filing fees effective from this year? They are effective on April 1st. This question is coming from Pavan Goratla. Can students who are pursuing masters, can they apply H-1B before the OPT got approved? This question has come from Monica. The answer is yes, but if you're not near completing masters, you can only apply in bachelor's quota instead of master's quota.
Siri says, can you please help on expediting AP approvals? Yeah, APs are ridiculous long processing times. I'm not seeing very many people able to get the expedited AP processing. It's not really possible for another attorney to submit an expedite request on your behalf, because we have to call USCIS to do it, and they won't talk to us because our G28 is not on file with your AP unless you filed it with our office. But we can help with litigation, and that is very useful in getting a faster result of your advanced parole. So if you're interested in that, Stephen Brown is the person to contact. He's done a ton of AP delay cases and able to get those advanced paroles approved.
Questions are coming from Twitter that how long is it taking for the H4 and H4 EAD nowadays? If you file H4 and H4 EAD together, it's taking anywhere between 4 months to 6 months. This is, typical 90% of the cases. It's taking 4 to 6 months to get the H4 plus EAD to get it approved. Now, there are some shortcuts available if your company is cooperative. This question is for Kastuba. If your company is cooperative, there are some shortcuts. When I say your company, the spouse's company, the person who has a H-1B, they can file an amendment and they can file a premium processing and get all H1, H4, and EAD approved at the same time. So you can see if that's something that you want to work with.
Kostub says, what's the current wait times for H4 and H4 EAD if I did not get selected in the H-1B lottery? So if you're filing a standalone H4 EAD, it can be anywhere from 4 to 8 months, and there's no premium processing for that, not really a way to expedite it. So you have to be careful of that timing if your OPT is expiring, because otherwise you won't be able to work during that gap period. But there's a workaround. If your spouse's H-1B employer is willing to file an amendment of the H-1B, even if it's not needed for any reason, if they file an amendment, they can do it in premium processing. along with the H4 and the H4 EAD, everything will get approved within the premium processing window, which is now 15 calendar days instead of, 15 business days, not 15 calendar days. But that's a much faster way to get it done if the employer is willing.
Do we have any information of the total H1B applications? We don't, but we're expecting anywhere between, based on the 25% selection, Emily, maybe somewhere between 300, 400,000, Emily?
Yep, that's what I'm thinking.
Ranyan has this question. We have submitted medicals in 2021. Our date is now current. Is it a good idea to send the medicals? Yeah, I will send the medicals again if I were you. Because it's medical expires every 2 years, they can't adjudicate. But if you send the medicals without an RFE though, it's only 50% probability it will reach your file. If you are willing to take that probability, do it. You may also want to consider, once you send the medicals, to probably go to court to get your green card though. The reason is that the priority dates are moving forward, backward. And if they don't adjudicate your application and the dates are current though, then you may lose the opportunity, because if the dates move back, you can't. And you can file a court case, and if you are interested in, contact Stephen Brown. He's the right candidate for you to look into if it's a litigation, if you want to litigate, what's the cost and what are the terms, he can discuss with you.
Vanaparthi says, can an OPT student start a company in the USA? Yes, for the initial 1 year OPT, self-employment is an option as long as the work you're doing for your company is directly related to your field of study. Now, it gets a little more complicated when you get into the STEM OPT, because by that point, your company needs to be an E-Verify company. And self-employment isn't technically allowed during that time. You need to likely add additional partners, other people who can take charge of the company, who have the ability to hire, fire, pay you, so you're not doing that for yourself. Now, there is a proposed regulation for H1B that would allow for self-employment even for H1B startups. We'll see if maybe that gets resolved before the election, would be my guess when that final regulation would come out. But at least for the first year of OPT, you can definitely do that.
Govinda Baveja has this question about the 60-day grace period. When he moved from company A to company B, he used grace period. Now, when he is moving from company B to company C, does he get a 60 days again, or he gets only remaining period of the 60 days? Between every company, you get 60 days. Between company A to company B, you get 60 days. Company B to company C, you get 60 days. Company C to company D, you get 60 days. It's not one time 60 days. It's every time you change from one company to another company.
SNV Rao says, if the H-1B was applied by 2 companies for a person, can both companies file the H-1B for approval? So I'm assuming you mean 2 companies registered in you in the lottery. You got selected, which means you got selections with both companies. So the technical answer is yes, you can. The real question is, should you do that? And I think that very much depends on the 2 companies and the 2 job offers. So if you're telling me that you got a job offer from Google and a job offer from Meta, and they both registered in you in the lottery and you got those selections, absolutely go ahead and file petitions with both and then decide which one gives you the better job offer to start working in October. But if you're talking about you work for ABC Consulting Company and then XYZ Consulting Company that you've never heard of, never worked with before, doesn't even have a real address, doesn't have an actual job offer, registered you in the lottery, and you want to file with both, don't do that, because XYZ company is likely a fraudulent company and you could end up with both being revoked. So stay away from that.
Rajam Sveta has this question from YouTube. She has the H4 I-94 extended, and she has the H4 EAD, excuse me, H4 EAD extension pending. I'm assuming that you filed the H4 EAD extension while the H4 EAD is still valid. So for example, if your H4 EAD is expiring in January 30th, you filed the extension before January 30th of 2024, and then it's still pending, you can work up to a period of 180 days if your H4 I-94. So for example, if your H4 I-94 is until June of 2024, and you file the H4 EAD extension before January 30th of 2024, you can work until 6 months from the time of January 2024.
Abhishek says, is there an alternative of E-Verify if the employer is not enrolled yet because I need to apply for my STEM OPT extension in a few months? No, there is not. So the employer has the option of enrolling in E-Verify now so that you and any future OPT employees who have STEM degrees can get the STEM extension. Or if they're not willing to do it, you have to find a new employer that is an E-Verify company in order to file for the STEM extension.
Emily, I want to discuss about this NIW with you, though. Now, we have seen that some of the companies are not pursuing the labor certification because they're getting a lot of applications that may be marginally eligible. Typically, though, in the industry, we hire the best people. When you advertise, when you get a resumes, we hire the best people. But when it comes to the perm labor certification, even if the person is basically eligible, not the best guy, then practically, if we don't hire them, we cannot file the labor certification. That's one of the reasons why a lot of companies are not willing to go through the labor certification process. Now, they are willing to file, what is this NIW? Can companies file NIW? They don't have to go to the labor certification. Can you explain how this NIW works? And can NIW be filed by individual without a company at all?
Yeah, so NIW stands for National Interest Waiver. It is the idea of the government waiving the job offer and therefore the need for a labor certification in order for someone to directly file the I-140 petition because their work is in the national interest. So you skip the labor certification. On top of that, you don't need a job offer, which means you can self-petition. So now you have the option, if your employer wants to, they can sponsor you in the NIW category. It falls under EB2. So if you are from India and you get the NIW approved, you're still in EB2. So you're still stuck in the backlog. Or you can file it yourself. In general, it's a very good idea to file it yourself because if the company files it, you may lose that NIW I-140 when you leave that company versus if you file your own, you can take that I-140 with you anywhere and you can always file the 485 as long as you are still planning to work in that particular field of endeavor that you got the waiver for. So NIW is a great option. I know a lot of people say, oh, it's still EB2, it's not worth it, what's the point? But if your company is having trouble with perm or they're delaying the perm or not filing it at all and you qualify, it gets you that approved I-140. You're a free agent. You're not tied to that employer for your green card anymore. And your spouse can get the H4 EAD. So yeah, it's still EB2, but it does have its benefits. It is useful.
Srinivas Vijay from Facebook has two different questions. If a H4 holder is working in the field of education, is it considered NIW? Is it a good idea to file a EB2 NIW? Just because you're working in the field of education doesn't automatically get you into NIW and get you an NIW approval, but you can be evaluated to see if you're eligible for NIW. He has a question. If a person who is moving from H1B to B1 or B2 because he lost the job and wants to intend to stay here for a period of 6 months to try to see if his luck to get a new job, can the kids at that point of time continue going to the school? Absolutely they can. No problem with that at all.
Runyon says, are you guys seeing any AOS approvals from the Texas Service Center recently? They seem to be the most backlogged. Texas doesn't process employment-based 485s anymore. So no, we're not seeing any approvals from there. They've all been transferred to the National Benefit Center, and that's where all of the adjudications are happening, either that or the field offices.
Emily, questions coming on NIW. Emily, questions coming on NIW. Does Reddy Neumann Brown, I have to get used to the name now. Do we help people at NIW?
Yes, we absolutely do. So you can reach out to either Kareem Giovanni or Ryan Wilk. Both of them handle NIW petitions. You can set up a consultation with them. They'll give you an assessment of your qualifications, what you need to do to qualify, what documents you need, and then they can help you with the filing as well.
Does pharmacist qualify for the NIW? Question coming from Subbu Paniswamy from Facebook.
Potentially. I mean, there's any job could potentially qualify under NIW. It's how can you describe what your field of endeavor is so that it's clear that it's in the national interest. So a lot of things that are related to healthcare definitely can be in the national interest. So I would definitely look into that possibility.
Anything else, Emily?
I think we're out of time for today. Thanks everyone for joining us, and we'll be back next Tuesday with Reddy Neumann Brown's weekly YouTube. And don't forget to subscribe to our newsletter if you don't already, so that you can get all of our updates by email with all the latest news.
Thank you very much.